Welcome to this meeting of the Standing Committee on Economic Development and Environment. My name is Katrina Knockleby. I am the MLA for Great Slave, and I am the acting chair of the committee. I'm now going to ask the members in the room to introduce themselves for the record.
Good morning, Alan Johnson, MLA for Yellowknife North.
Kevin O'Reilly, Frame Lake.
Thank you, and to the members online.
Jane Whelan Armstrong, MLA for Mulkey.
Ron Boniters, Dead Choke.
Thank you very much. And in the room, we also have with us our committee staff. We have Harji Sidhu, who is our manager of research. We have Joseph Levine, who is the committee advisor. We have Amy Lazat, who is our clerk, and our law clerk, Catherine Haid, in the back there. And Toby Kruger, our other law clerk, is online. So this morning, the Standing Committee on Economic Development and Environment is reviewing Bill 74, Forest Act. This bill is available on the Legislative Assembly website. Bill 74, Forest Act, received second reading in the Legislative Assembly on March 9th, 2023, and was referred to the Standing Committee on Economic Development for review. Bill 74 repeals and replaces the previous Forest Management Act and the Forest Protection Act, creating one new Forest Act. It is committee's job to review legislation and provide feedback while holding the government accountable. Committee has carefully reviewed Bill 74, soliciting feedback from forest stakeholders and the public. Committee held public hearings in Yellowknife and traveled to Wattie, Fort Simpson, and Enterprise to consult on this bill. Committee used this feedback to inform its discussions with the department and the technical working group about possible amendments to the bill. My apologies, I just realized that we also have members of the technical working group online. So I do apologize for that, and I will ask you when I finish reading to introduce yourselves. My apologies. The clause-by-clause review today is a result of all this work. Standing Committee would like to thank the Minister, the technical working group, and staff for facilitating collaboration with Committee to discuss possible amendments on this bill. I will now invite the Honourable Shane Thompson, Minister of Environment and Climate Change, to deliver any opening remarks on Bill 74. Following the Minister's remarks, Committee can provide comments on the bill or ask questions of the Minister. Following this, Committee will proceed with a clause-by-clause review. Minister Thompson, please introduce your staff for the record. Please also introduce representatives from the Technical Working Group and proceed with your opening remarks.
Thank you, Madam Chair. I appreciate the opportunity to be here today to discuss Bill 74, the Forest Act. I'm here today with Dr. Aaron Kelly, Deputy Minister of Environment and Climate Change, Dr. Brett Elkin, Assistant Deputy Minister of Wildlife and Forest Management, Mike Corbell, Director of Forest Management Division, Dennis McCurry, Director of Policy, Legislation, Evaluation and Communication, Melissa Barr, Manager of Legislation and Legal Affairs, Laura Jeffries, Legislative Counsel for the Department of Justice, Rohan Brown, Legal Counsel for the Department of Justice, and Krista Ingram, Acting Ministerial Special Advisor. I'm also joined by many members of the Intergovernmental Council Secretariat Forest Act Technical Working Group, including Peter Redverse, representative of the Cadtici First Nation, Paul Beauchart, representative of the Clecho Government, Willard Hagan, representative of the Quitchin Tribal Council, Nick Dormier, representative of the Akodeni Co First Nation, Valerie Gordon, representative for the Sawtooth Secretariat Incorporated, and there may be other Indigenous governments and organizations involved in the drafting of the bill on the call as well. These representatives are joining us today in accordance with the Process Convention on Introduction, Consideration, Enhancement of Bills drafted pursuant to the Intergovernmental Council Legislative Development Protocol. The Department of Environment and Climate Change has worked closely with Indigenous governments and Indigenous organizations through a technical working group to develop Bill 74 from the Intergovernmental Council Protocol. The Forest Act bill presented to the Legislative Assembly reflects the hard work of many people and organizations and reflects consensus of parties under the protocol. Bill 74 combines modernized the current Forest Management Act and Forest Protection Act. It will allow the GNWT and its partners to use the most current tools to effectively manage forest resources in the NWT and ensure forest ecosystems are enjoyed for generations to come. New tools established under Bill 74 include forest ecosystem management plans, provisions required to allow GNWT to effectively manage wildfires, the ability to take immediate action under invasive species and diseases that can cause serious harm to a forest, remove the requirements for a permit for anyone with Aboriginal treaty rights to harvest forest resources in an applicable area, modernized appeal process, and update enforcement and investigation authorities. I'd like to thank the Standing Committee on Economic Development and Environment for the review of this bill. In the spirit of cooperations, the IGC Technical Working Group and committee staff worked through several motions that may be introduced today. I believe that the bill will be improved as a result of this work. I look forward to today's clause-by-clause review of Bill 74 and look forward to answering any question committee may have. I invite any members of the Technical Working Group to say their opening remarks. Thank you, Madam Chair.
Thank you, Minister. I agree. It's been a great collaborative process on this bill for the first one. Were there any members of the Technical Working Group online that would like, or in the room that would like to speak before we get started? Just give everybody here a second, find their mute buttons if they need to, or send us a message, or come on camera.
Well, there. Sorry about that, Madam Chair. It's,
No, go ahead,
Paul
Paul.
Bachon.
Yeah, go ahead.
It's Paul Bachon here, counsel for Cleatron government. I just bring you our best regards on behalf of the Cleatron government. Brett Weber, who has the lead from Cleatron government staff, was unable to be here today, and it's my pleasure to be in his stead. We're really happy to be here, in as much as this really represents the work of two successive governments to try and get a new and expanded and more appropriate Forest Act into being, and we're happy to be here to do that. That 8-year process, we hope, will culminate soon. Thank you.
Thank you. Yes, we're looking forward to having this one, I think, get finalized and finished. So, Mr. Redvers, would you like to say some words?
Yes, just to reiterate, Peter Redvers, I'm the lead negotiator with the Kotla First Nation. Just like to reiterate what Paul Bachon has indicated, that it's been quite an interesting and productive, if somewhat long, process. But the intent is to have an act that there can be consensus on. So certainly thank you for participating. This has been a first implementation of the process protocol with SCEDI, Legislative Assembly, and certainly is a step forward in creating this type of legislation. So, Masicho.
Thank you. Are there any others, or should we proceed to the clause by clause? Okay, I don't see anyone else. So does committee agree to proceed to a clause by clause review of Bill 74, the Forest Act? Mr. O'Reilly?
Sorry, I'll get it right. Yeah, I do have a few comments I was hoping to make, and then a couple of questions, if I could, for the minister. Yeah, I do want to just take a minute to, this is a historic event. This is the first time that Indigenous governments have been involved in a standing committee review of a bill, proposed legislation in the Northwest Territories. This doesn't happen anywhere else in Canada, and I think this is a good thing. And I think committee agrees and supports the legislative development protocol and the process convention that the minister referred to as well. This was a collaborative process, and we have a substantially better bill than what we had in the last assembly, Bill 44. We have much improved integration of co-management, stronger provisions to recognize Indigenous rights. There's a better flow organization and process for forest management and fire set out in this new bill. And I think we're going to deal with a number of amendments that we worked together on. I also want to recognize that we had a number of written submissions as well. We did travel, but the written submissions were very helpful. Our work was hampered by the fires, unfortunately. We had hoped to go to a few additional communities, but that didn't happen. And of course, there is significant public interest in this issue, and I just want to take a moment to thank the firefighters and staff of the department for all the work that they're doing to protect our communities, because that's really important work. There's a lot of people that are, we've had a really rough summer here, so I guess I will note too that we heard a lot of other concerns in the public hearings that relate to policy matters and practices, and I think you'll be getting some comments and recommendations from committee in our report on those. They're really outside of the scope of the legislation itself, but I think that's what I was hoping to say in terms of some opening remarks, and I'll probably have some at the end as well, Madam Chair, but I do have maybe a couple of questions for the minister, and I'd like to just understand how, what is the interpretation of how this act is going to apply to privately owned lands? Thank you.
Thank you, Mr. O'Reilly. Mr. Minister, would you like to take that?
I'll turn it to Deputy Minister Kelly, please.
Dr. Kelly, please go ahead. Can we go to Melissa, please? Where's there? Yeah.
Thank you, Madam Chair. The Bill 74 is a law of general application and applies broadly across the NWT. And there are elements that do apply to private land. And of course, in regulations, the intention is to carve or clarify some of how the applicability will work. And I'll just ask Rohan Brown, legal counsel, if he has anything to add to that.
Mr. Brown, go ahead.
Okay, thank you. I don't have anything to add to what Ms. Bard said. Thank you.
Thank you. Mr. O'Reilly, do you have a follow-up?
Yeah, thanks. Sorry, I'm not supposed to touch it. Yeah, we did receive public correspondence from the minister, or sorry, the government house leader on this issue. And it says that the determination of such potential narrowing with respect to settlement lands, and I presume that means Indigenous owned lands, other private lands and federal lands remain to be made in the regulations. So that was an area of concern for the committee, and I think we're going to have some comments about that in our report. But I just want to clearly get on the record that what is the practice going to be in terms of issuing permits and licenses on privately owned lands outside of the settlement lands? Thanks.
Thank you. Mr. Minister?
Turn it to Deputy Minister Kelly, and she can direct it from there. Thank you. Or to Mike Crevel. Sorry.
Thank you, Minister. Mr. Crevel?
Thank you, Madam Chair. Thank you, Madam Chair. Yeah, so as stated, the bill will be a law of general application as it stands, but when we go to regulations, it will clarify that provisions under wildfire management will apply to all lands, so for the safety of public. However, other provisions such as permitting will be restricted to public lands. So the bill will not apply to leased lands, private lands, Indigenous owned lands. Ourselves and the technical working group and the Indigenous governments all have that same understanding. And when we go through the regulations, that's how they will be built. Thank you.
Thank you. Before I go to, you're good? Okay. Would anyone else like to speak before we get started with the motions? Not seeing any from members, we will move on then. So does committee agree to proceed to the clause-by-clause review of Bill 74, the Forest Act? Okay. We will defer the title of the bill until the end and begin with consideration of the clauses. Where possible, I will call clauses in groups. Does committee agree? Committee, please turn to page 1 of the bill. Clause 1 through 6, does committee agree? Clause 7, MLA Bonnet Rouge? MLA Johnson, do you want to read?
Thank you, Madam Chair. I move that paragraph 7 be of Bill 74 be amended by striking out working relationships for effective. Thank you.
Thank you. The motion is in order. To the motion, Mr. O'Reilly.
I'll try to remember not to touch it. Thank you, Madam Chair. I make it a practice of trying to speak to motions where we're amending bills at committee so the public actually understands what we're doing and how we're changing things. So I want to thank CPAWS and Alternatives North for a very helpful submission that they made with the assistance of Tollefson Law, which is a firm out of BC. And they suggested removing what's probably some extra words here to this section, which really sets out the purpose of the act. So the focus is not so much on working relationships as it is in collaborative and cooperative sustainable forest management. So the suggestion came from them, and I want to recognize that. And I think this is an improvement in focusing on the things we need to do in terms of the purpose of the legislation. Thanks, Madam Chair.
Thank you. Would any other members like to speak to this motion? Just check our chat here. I don't hear anyone, so the motion is in order. To the motion? Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with the amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. This change will help clarify our approach to cooperative forest management. Thank you, Madam Chair.
Thank you. The minister concurs with the amendment. Thank you, Minister. Clause 7 is amended. Committee to Clause 7 as amended. Oh, sorry. Does committee agree? Yes, agreed. Thank you. Clauses 8 through 10, does committee agree? Clauses 11 through 13, does committee agree? Clause 14, MLA Johnson.
Thank you, Madam Chair. I move that Bill 74 be amended by adding the following after Clause 14. 14.1. The minister shall, as soon as is practical, or within a time period set out in the regulations, make the following information respecting the operation or administration of this act publicly available by publishing on a website maintained by the department. A. Any Forest Management Committee establishment agreements entered into under Section 10. B. The powers and duties given to officers by the Forest Superintendent under subsection 17 sub 2. C. Any forest ecosystem management plans developed under subsection 24 sub 1. D. Any extensions or variations of the wildfire season declared under subsection 28 sub 2. And E. Any prescribed information. Thank you, Madam Chair.
Thank you. The motion is in order. To the motion, Mr. Johnson.
Thank you, Madam Chair. Initially, committee started off with a much larger prescriptive list of what we would like to see published to a website. I'm happy to kick, a lot of that to regulations. I think the department and the technical working group raised some valid concerns of figuring out exactly what things are. One thing committee heard specifically is in a lot of communities, people talked about where fires had been historically, and they wanted to know. I believe we actually provided Wati with some of their historical fire data, but we went, and when we got a tour of the fire center, ECC has all that data set showing fires when they go back, and we heard repeatedly this kind of community piecing together of when fires had happened over the decades. And so that just, there's a lot of great data sets there that are being used to track aircraft and values at risk, and I think, some thought has to be given to what is immediately public, but I think a lot of that data, there'd be a lot of public interest in making sure people know, especially as these fire seasons become worse and worse. Thank you, Madam Chair.
Thank you, Mr. Johnson. Mr. O'Reilly.
Yeah, thanks, Madam Chair. Sorry, I've got a few things I want to say about this. We did go back and forth a lot on this particular clause, and this is really about establishing whether important documents and decisions on forest and fire management should be public and how they should be made public, because the bill was totally silent on that. And I want to note that this issue was raised in the last assembly with regard to Bill 44. It was raised by committee during discussions we had with the department. It was raised during the public engagement earlier this year on the bill. This issue was contained in submissions we received from NWTAC, Northwest Territories Association of Communities, and from the non-governmental organizations. And it's my view that it can and probably should have been dealt with a lot earlier in the bill. And I don't think this was the responsibility of the Indigenous governments. Let's get very clear. This is a governmental responsibility, and it's really about responsible resource development. So as my colleague, Mr. Johnson, indicated, the committee had developed a very extensive list of what we felt should be in or made available to the public. But I guess this is what we've kind of landed on for now. There seems to be some reluctance on the part of the department to spend money to do this work, and but I believe it's actually required by Cabinet's open government policy, and it's consistent with other resource management legislation that we dealt with in the last assembly. There's a public registry in the Protected Areas Act, the Mineral Resources Act, the Public Lands Act, and we even put a public registry into the Elevators and Lifts Act in this assembly, something as mundane as that. So. And the issue of resourcing, I think, has been raised, but, you know, at the time of devolution of forestry to the territorial government, we got an offset in the territorial formula funding that's indexed over time of $24 million. Current value is about $55 million. And in a normal year, as I understand it, for forest and fire work, we spend about $35 million. This is obviously an exception. But so I think there's more money that is available, or it just goes into the consolidated revenue fund or through the territorial formula funding arrangement to do forest management. So, and I would point out that industry, tourism, and investment did secure additional resources for what's going to become their public registry under the Mineral Resources Act, and I think the department is going to need to get additional money to take on much of the new responsibilities in this legislation as well. But I do support this, and I believe in it very strongly, and I think we're going to have some further discussion about this following this motion as well. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. Are there any other members that would like to speak to this motion? Seeing and hearing none, the motion is in order. To the motion? Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this amendment to the bill. The government of Northwest Territory is committed to public access to government information and balance commitments with the cost of maintaining websites and many other considerations. So yes, Madam Chair, we concur. Thank you.
Thank you. The minister concurs with the amendment. Thank you, Minister. Sorry, which one? The motion is carried. Sorry. Is it this one? Sorry. Does a committee agree to clause 14 as amended? Mr. O'Reilly.
Yeah, thanks, Madam Chair. I move that clause 14.1 of Bill 74 be amended by A, renumbering that clause as subclause 14.1 brackets 1, B, by deleting paragraphs B and E of that renumbered subclause and substituting the following. D, any forest harvesting agreements entered into under subsection 25.1. E, any extensions or variations of the wildfire season declared under subsection 28.2. F, all wildfire prevention and preparedness plans submitted to the forest superintendent under subsection 45.2, any such plans resubmitted under subsection 45.3, and any hazard assessments conducted under subsection 45.5. G, all permits and licenses issued under subsection 48.2, other than those that authorize the holder to undertake activities set out in that subsection solely for personal purposes. H, any prescribed information. C, adding the following after the renumbered subclause. 2, before publishing a forest harvesting agreement under paragraph 1D, the minister may remove from the agreement any of the following information, the disclosure of which would be prohibited pursuant to the Access to Information and Protection of Privacy Act. A, any ecologically or culturally sensitive information. B, any information harmful to the financial or economic interests of a party to the agreement. 3, information is not required to be published under subsection 1 if the information A is prohibited from disclosure under an act of the North of Canada or an act of the Northwest Territories. Or B, is provided implicitly or explicitly in confidence to a person or body exercising power or performing duties or functions under this act and is consistently treated as confidential information by the party providing the information. Thank you, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion, Mr. O'Reilly, go ahead.
Yeah, thanks, Madam Chair. That's a lot of words to say that what committee would like to do is to actually broaden the list of things that would be made public from what have initially agreed to. And the things that would be added are forest harvesting agreements. And I think the intention there is that this is use of public resources, and there should be some transparency around the use of those and development of those. Or once an agreement is negotiated, it should be made available to the public, subject to not releasing information that could hurt the business. The other thing would be prevention and wildlife prevention and preparedness plans and hazard assessments. Those, in our view, should be public as well. And permits and licenses, other than those that are for personal use. I think we heard from the department that if all the permits and licenses were to be made available, it might be 1,000 per year, because many of them are personal use. So we tried to craft this in a way to respond to that by excluding personal use permits and licenses. But how else do people know about what is going on if permits and licenses are not available to the public? So, and then committee has added some additional words here, protections at the end of this that aren't even in the government or the bill that we just dealt, or sorry, the motion we just dealt with, about protecting ecologically and culturally sensitive information that might be in forest harvest agreements and information that might hurt businesses, and any information that would be posted, about the agreements would have to be consistent with ATIP. And those protections were actually lifted from the Protected Areas Act and some other legislation that we dealt with in the last assembly. So we tried to find a little bit better balance in our view of what information should be made public now, recognizing that there is going to be further work done in the regulations. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. Would any other members like to speak to this motion? Hearing none, the motion is in order. To the motion? Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. Process convention pursuant to the IGC Legislative Development Protocol requires that all proposed amendments be reviewed and the GNWT's response provided no later than 1 week before a clause-by-clause review. Though this motion was not provided by committee in time to be reviewed, we cannot support the motion because additional items committee wish to add to the website are agreements and industry's plans. These details are intended to be outlined in regulations after engagement with all stakeholders. At this point in time, I'd like to ask you, the chair, to ask Paul Beauchamp from the Cleacho government to comment on this as well. Thank you.
Thank you, Mr. Bichon. Go ahead.
Thank you, Madam Chair. It's a great opportunity to respond. Thank you, Minister. And we just wanted to note the technical working group, when looking at this go around in relation to the Forest Act, had carefully considered the listing of the type of information that should be provided to the public. And Member O'Reilly is correct that there needed to be an improvement. And we thought that the improvement made by the technical working group to add the information in A through D of an original motion fit the bill quite well. And as might be a theme you might hear today, the technical working group was satisfied that to get this bill past the finish line, there would be certain matters that would be appropriate for more careful consideration during the phase where regulations are in place. In other words, some of the information that's in this further amended motion 2.1, we think needs to be studied carefully in terms of operations when we're speaking to the publication of all permits and licenses and extensions and variations of wildfire seasons and how that might affect operationally. It doesn't mean that the technical working group is reflexively or opposed to the publication of information. What it favors is the further study of the types of information that can be made public through the regulatory process. We think that would implement the direction set in the original motion number 2. Thanks for the opportunity.
Thank you, Mr. Bachand. The minister does not concur. The amendment will not take effect as a result. The minister did provide concurrence on the previous amendment to this clause. So committee, to clause 14 as amended. Does committee agree? Clause 15, MLA Johnson?
Thank you, Madam Chair. I move that Bill 74 be amended by adding the following after clause 15. 15.1 sub 1. The force superintendent shall, not later than December 31st following the end of each year, deliver to the minister a report on the activities of the force superintendent under this act for that year. That includes A summary of any activities of the force superintendent under subsection 23 sub 2. Any forest ecosystem management plans developed under subsection 24 sub 1. Any monitoring under subsection 26 brackets 1 and brackets 4. Any forest renewal activities funded under subsection 57, and B, any prescribed information. Sub 2, the minister shall, upon receipt of a report under subsection 1, make the report available to the public by publishing it on a website maintained by the department. Thank you, Madam Chair.
Thank you, Mr. Johnson. To the motion, question, sorry. Go ahead, Mr. O'Reilly.
Yeah, thanks, Madam Chair. Yeah, so this motion would create a new requirement for an annual report from the forest superintendent. And the forest superintendent is an important position that's created in the legislation, and this is the individual who will be responsible for working towards developing forest ecosystem management plans with Indigenous governments, and basically implementing a lot of the new processes and provisions in the legislation. So what committee heard when we went to communities was that they wanted, some people in the public wanted some more greater accountability in terms of forest decision-making. And in the written submissions, we also heard the concerns about the discretionary nature of the authority of the forest superintendent. The forest superintendent may prepare forest ecosystem plans. The forest superintendent may monitor the state of the forest ecosystem. So there's a lot of mays rather than shall. And to help, I think, get around that issue, one of the ideas that we developed was this idea of an annual report, so that there could be some explanation as to what that position was actually doing in terms of the important new processes and tools in the bill. So that's the purpose of this, is to create some little bit of a check there, balance in terms of this new position, and provide a communications tool as well back to the public about what kind of activities are taking place. So that's really the rationale and the purpose of this amendment. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion? Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. The Department of Environment and Climate Change is committed to transparency and accountability through its annual report on key forest management activities. We do an annual forest health report now, and we'll enhance it moving forward. So we concur. Thank you, Madam Chair.
Thank you, Mr. Minister. The motion, oh, I'm losing my spot. The minister concurs with the amendment. Thank you, committee, to clause 15 as amended. MLA O'Reilly.
Thanks, Madam Chair. I move that Bill 74 be amended by adding, better get the right one here, the following after clause 15.1 brackets 1 of Bill 74 be amended by adding A, the following immediately preceding subparagraph A, Roman numeral 1, 0 point Roman numeral 1, any significant research activities of the forest superintendent under paragraph 15.3b, deleting and at the end of the English version of subparagraph A, Roman numeral 4, and substituting a semicolon, and C, deleting paragraph B and substituting the following. B, the total number of inspections and investigations conducted under Part 7. C, the total number of fines and other penalties imposed under Part 8. And D, any prescribed information. Thank you, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion. Mr. O'Reilly.
Thanks, Madam Chair. So there's a lot of fancy words here, and what this is about is, although we've agreed to together to create an annual reporting requirement for the forest superintendent, I guess committee had hoped that there would be some additional things that the forest superintendent would report on, and in particular research activities, which the forest superintendent duties and powers are really set out in section 15, and there's really nothing in the current reporting that we just approved in the last motion that deals with those powers and duties of the forest superintendent at a higher level. So we wanted to include research, and we also felt that it would be important to include some understanding or some reporting about what kind of inspection enforcement activities are taking place, and that's what Part 7 and Part 8 of the Act are all about, so that we could maintain public confidence that those activities continue to be taking place, and that there could be some understanding of the capacity of the department, the resources that they have dedicated to those activities to maintain public confidence in them. So we felt that those were important things to set at a minimum in the report from the superintendent, and that's the purpose of this amendment. And we did provide this ahead of time to the department in the interest of, fairness and transparency, and may not have been with enough time on their part at their end, but we kind of have all run out of time, but committee felt that it was important enough to bring this forward for discussion and debate here today in the clause by clause. Thank you, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion? Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. Process convention pursuant to the IGC Legislative Development Protocol requires that all proposed amendments be reviewed and the GNWT's response provided no later than 1 week before clause-by-clause review. This motion was not provided by committee in a time to be reviewed by the technical working group and cabinet. Further addition of significant research of the forest superintendent presents some legal ambiguity. At this point in time, Madam Chair, through your permission, I'll ask Paul Beauchamp from the Cleacho government to add further comment. Thank you.
Thank you. Mr. Bashan, go ahead.
Thank you. And
Mr. Bashan, I think we've lost your audio. Can you hear me?
can you hear me now?
Yes, I can. Go ahead.
Okay, sorry about that. That was my fault. On behalf of the technical working group, we did have despite the process convention requirements, there was a discussion of the newly added amendment in relation to the word significant research activities. And I guess we would note that these words are, to be honest, kind of vague. One example that came up in the discussion had regard to, well, if the forest superintendent ends up doing some significant research activities, say by looking at IPCC reports over a number of years or decades and doing studies internally related to that, is that a significant research activity? Does the research activity have to be contracted to become a research activity? What resources are devoted to that, and what in the end does a significant research activity end up being? And again, that doesn't mean that idea doesn't warrant good consideration. We think it can warrant good consideration in the discussions that will be upcoming once the act is in force in relation to the prescribed information that will go into an annual report. Thank you.
Thank you. And yeah, just for the public's sake and knowledge, that's kind of what committee's thought is as well. We knew that perhaps, that we had run out of time, but wanting to make sure that some of this got captured and that it was in the public record and reports so that it could carry forward when the regulations were being developed. So just wanted to add that. The motion is in order. To the motion. Am I at that part? Nope, I'm in the wrong part. Sorry, the minister does not concur. It has been a very long week of, this has been a very, very big bill. So sorry, the minister does not concur. This amendment will not take effect as a result. The minister did provide concurrence on the previous amendment to this clause. Committee to clause 15 as amended. Does committee agree? Clause 16 through 20. Does committee agree? Clause 21. Does committee agree? Clause 22, MLA Whalen Armstrong?
Yes, I move that the subclause 23, bracket 3 of Bill 74 be amended by striking out the quotation, the minister may
Sorry,
implement-
MLA Whalen Armstrong, I don't mean to cut you off, but I believe you said the wrong number for the subclause, and I do have to correct you. So if you could start again, that would be great. Thank you.
Sorry about that. Okay, I move that subclause 22, bracket 3 of Bill 74 be amended by striking out the minister may implement those aspects at their discretion and substituting the minister may upon provision of written reasons for the decision to the parties to the dispute resolution process, implement those aspects at the minister's discretion.
Thank you, MLA Whalen Armstrong. The motion is in order. To the motion. MLA O'Reilly?
Yeah, thanks, Madam Chair. I guess I'd like to start by thanking the Waukesha Land and Water Board that made a written submission to the committee with this suggestion, and I think it's a sound one. And what this is really about is there is a dispute resolution process laid out in the legislation. And of course, the legislation is really founded on this concept of collaborative forest management. And so where the minister is working with Indigenous governments to, implement parts of the legislation, if they can't agree on things, there's a dispute resolution process laid out here. That's what's found in Section 22. And this provision, though, would, and 22.3 allows the minister, where people can't reach consensus, to go ahead and take action when the minister deems it necessary. So what this would do is actually ensure that there's some written reasons that are provided in that particular circumstance. So at least the Indigenous governments, maybe the public at some future point, might get that information as to the rationale for that. So that's what this is all about. And again, I want to thank the Waukesha Land and Water Board for that suggestion. I think a very helpful one in terms of improving accountability. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. To the motion, or sorry, the motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. This change helps clarify the Forest Act's approach to dispute resolution process, so I concur. Thank you, Madam Chair.
Thank you. The minister concurs with the amendment. Clause 22 as amended. Does committee agree? Clause 23, does committee agree? Clause 24, MLA Bonnet Rouge.
I move that clause 24 of Bill 74 be amended by A, adding a semicolon at the end of the English version of paragraph 1, subclause A, and B, adding the following after subclass 1. 1.1, in developing a forest ecosystem management plan under subsection 1, the forest superintendent shall consider potential impacts of a changing climate on the relevant area of forest, including by considering any relevant indigenous traditional knowledge, modeling, data, and trends.
Thank you, MLA Bonnet Rouge. The motion is in order. To the motion. MLA O'Reilly.
Yeah, thanks, Madam Chair. So I think this is pretty self-evident. We're living in times of a climate crisis or emergency, and this was brought to the attention of committee during its travels and in all the communities that we visited, and was raised in written submissions from the Northwest Territories Association of Communities and by the non-governmental organizations as well. So, this is why committee has brought this forward, to ensure that when those forest ecosystem management plans, which are the foundation of forest management, the foundation in the bill itself, that there is that they will include consideration of climate change. So that's the purpose of this motion. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion. The question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. The department is aware of the need to consider climate change in forest management. This change clarifies our approach to the forest management system management program, so I concur. Thank you, Madam Chair.
The minister concurs with the amendment. Thank you, Mr. Minister. Clause 24 as amended. Does committee agree? Oh, sorry, MLA Johnson.
We're amending this clause one more time.
Yeah, sorry.
I move that Bill 74 be amended by adding the following before subclause 24, sub 2, 1.2. The forest superintendent shall ensure that there is an opportunity for public engagement during the development of a forest ecosystem management plan under subsection 1. Thank you, Madam Chair.
Thank you, Mr. Johnson. The motion is in order. To the motion. Mr. O'Reilly.
Thanks, Madam Chair. Yeah, this issue of the need for some kind of public participation in forest management enshrined in the legislation itself. This was raised in the last assembly on Bill 44. It was raised by committee discussions with the department. It was raised during the public engagement on this during the development of this bill. And I want to make it clear, this is not a responsibility for the Indigenous governments. This is a governmental responsibility, and probably should have been addressed in the bill, but now we're finding ways to fix that. So it was raised in written submissions again to committee by the NGOs and by the Northwest Territories Association for Communities. So I want to thank them for raising the issue as well. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. The department engages the public during the development of the forest ecosystem management plan and supports this clarification. With your permission, I would like to ask Peter Edwards from Kaddichi First Nations to speak on to this motion as well. Thank you, Madam Chair.
Thank you. Minister, Mr. Redvers? Sorry, I'm not sure if my mic was on. Mr. Redvers, go ahead.
Yes, yeah, thank you on that. Yeah, certainly one of the reasons for introducing the notion of a forest ecosystem management plan and that process was to get upstream as far as possible from the issuing and the review and the issuing of authorizations and permits, which is where generally conflict has occurred. It's most certainly between KFN and what was ENR at the time in the Forest Division. And so by doing that upstream planning and making sure that along with the involvement of the Indigenous government, but any other interest holders have an opportunity to have input into that, we can make sure that we have a plan that then can be followed throughout all of the other processes that follow, including forest management agreements, forest authorizations, and permits. And if the forest ecosystem management plan is being done properly, then there's less need further down the stream for continued kind of public engagement, or in some, obviously there would be consultation in terms of specific infringement of rights. But if the planning is done up front, then that's really where the work is best done in relation to how to manage the forest in a particular area. And so in terms of supporting that, which I believe that we have this point, no issue with public engagement in the forest ecosystem management plan, then it reduces the need for an ongoing or continued kind of engagement with respect to the further downstream in terms of some of the management agreements and authorizations and permits. In a sense, it becomes like a land use plan. It guides all of the other decisions appropriately.
Thank you, Mr. Redvers. The minister concurs with the amendment. Thank you, Minister and Working Group. Clause 24 is amended. Committee, to Clause 24 as amended, does committee agree? Agree. Clause 25, MLA Whale and Armstrong.
I move that Bill 74 be amended by adding the following after subclause 25, bracket 1, 1.1. The minister shall ensure that there is an opportunity for public engagement prior to entering into a forest harvesting agreement under subsection 1, bracket 1, for an area of forest where no forest ecosystem management plan has been developed. Thank you.
Thank you, MLA Whale and Armstrong. The motion is in order. To the motion, MLA O'Reilly.
Yeah, thanks, Madam Chair. So this issue of, so the bill did not provide for any kind of public engagement on the forest harvesting agreements. And this issue was raised to committee by, or was raised in the last assembly. It was raised again during the public engagement on this, during the development of this bill. It was raised again to committee in written submissions by Northwest Territories Association of Communities and the NGOs. So I guess what they had really requested was an opportunity for public engagement on any forest harvesting agreements that are negotiated. So I guess the compromise that was reached was that for those agreements where there is no ecosystem management plan, will now be a requirement for public engagement. So I think the rationale here is that the public engagement that happens around the forest ecosystem management plans is sufficient and adequate to allow for forest harvest agreements to be negotiated later. And I think that might be okay, but my personal preference is that all forest harvesting agreements where we're starting to commit to develop areas, there should be the opportunity for the public to have a say, but this is the compromise that's been reached. I'm hoping that the department will actually allow for all harvest agreements to go through some form of public engagement, because the engagement around a forest ecosystem management plan shouldn't be a substitute for good resource management, good public engagement, public involvement period. So anyways, that's my views, but I recognize that this is a compromise and it's better than nothing that was in the bill. So I'm just putting that out there for the record. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. ECC is committed to transparent accountability through public engagement on government decision-making, including the development of the forest harvesting agreement. So I concur. Thank you, Madam Chair.
Thank you. The minister concurs with the amendment. Clause 25 is amended. Committee to Clause 25 as amended. MLA Bonnet Rouge.
I move that Bill 74 be amended by adding the following after subclause 25 brackets 2. 2.1, the forest harvesting agreement entered into on subsection 1 must be consistent with any applicable aspects of
Sorry,
the forest.
MLA Bonnet Rouge, I don't mean to interrupt you, but I think that we are on the one on page 12. Motion 9. Subclause 25 bracket 2 of Bill 74.
Documents. Okay, I move that subclause 25 brackets 2 of Bill 74 be amended by striking out forest management plan and substituting forest ecosystem management plan.
Thank you, MLA Bonnet Rouge. And just so the public's aware, we have about 30 pages here, so that's why it's a little bit confusing for us to keep on task here. So the motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. This change corrects a typographical error, and the department appreciates this catch. Thank you, Madam Chair.
Thank you, Minister. The minister concurs with the amendment. Clause 25 is amended. Committee to Clause 25 is amended. MLA Bonnet Rouge.
I move that Bill 74 be amended by adding the following after subclause 25 brackets 2. 2.1, the forest harvesting agreement entered into under subsection 1 must be consistent with any applicable aspects of a forest ecosystem management plan that have been implemented in respect of the area that is covered by the agreement.
Thank you, MLA Bonnet Rouge. The motion is in order. To the motion. MLA O'Reilly.
Yeah, thanks, Madam Chair. Yeah, this is again an issue that was raised in the last assembly on Bill 44. It was raised in written submissions during the public engagement on this bill and was raised in the NGO submission written to us in our review of the bill. So this has been around for a while. And I guess through negotiation, this is what we've arrived at. I am still a bit concerned about the wording here because it talks about a forest ecosystem management plan that has been implemented. We had a lot of back and forth about when a plan sort of comes into effect and how it might bind a forest harvesting agreement. And I believe Mr. Redvers put it the best. These plans are meant to be the foundation of the process here for forest management, and it's kind of like a land use plan. It is binding on what comes after it. So the purpose of this is to clarify that forest harvesting agreements need to be consistent with plans when they're completed and agreed upon, I guess. I'm still worried about the word implemented, but that's the purpose of this, is to try to deal with avoiding conflicts and deal with the stuff upstream, I believe, as Mr. Redvers indicated. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. The change helps ensure that the forest harvesting agreements are consistent with the forest ecosystem management plans. I concur. Thank you, Madam Chair.
Thank you, Minister. The Minister concurs with the amendment. Clause 25 is amended. Committee, to Clause 25 is amended. Does committee agree? Agree. Clause 26, MLA Johnson.
Thank you, Madam Chair. I move that Bill 74 be amended by adding the following after paragraph 26, sub 1, sub E, E.1, climate change impact. Thank you, Madam Chair.
Thank you. The motion is in order. To the motion, Mr. O'Reilly.
Thanks, Madam Chair. What this motion does is, I talked earlier about the creation of a position of forest superintendent in the bill, and that's an important position. One of their responsibilities is that they may monitor the state of forest ecosystem in the Northwest Territories. We talked about may versus shall, but in terms of the annual reporting. But anyways, in terms of monitoring the state of the forest ecosystem in the list that had been prepared in the bill, I guess you might infer that climate change is in there, but we thought that it would be far better to get it explicitly recognized. And so that was the purpose of this. And I mentioned when this issue kind of came up in a previous motion, we had this issue of climate change raised to us several times in writing and in the public hearings, and we thought very carefully about how we could try to insert that issue into the forest management processes that have been set out in the bill. And we thought that in the forest ecosystem management plan was a good place, but also in the monitoring that the forest superintendent will carry out. And that was the purpose of this amendment here, is to ensure that the forest superintendent considers climate change when doing monitoring. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. The departments recognize the importance of monitoring climate change impacts in our forest ecosystems. So I concur. Thank you, Madam Chair.
Thank you. The minister concurs with the amendment. Clause 26 is amended. Committee, to Clause 26 as amended. Does committee agree? Clauses 27 and 28. Does committee agree? Clause 29, MLA Whale and Armstrong.
I move that subclause 29, bracket 3 of Bill 74 be amended by striking out kindle in, and substituting burning in. Thank you.
Thank you, MLA Whale and Armstrong. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. This change clarifies the language of the bill, which helps to ensure the public does not misinterpret initiation or integration within a stow forest or other devices. I apologize. I'm not having a good day. Thank you. I concur.
I think we've all hit our wall, Mr. Minister, and I think the word you were looking for is ignition. The minister concurs with the amendment. Thank you, Minister. Clause 29 is amended. Committee, to Clause 29 is amended. Does committee agree? Clauses 30 through 37, does committee agree? Clause 38, MLA Johnson.
Thank you, Madam Chair. I move that Bill 74 be amended by deleting Clause 38 and substituting the following. 38. The forest superintendent shall take steps required by the regulations to notify the public where A, a prescribed burn other than one on or near an existing wildfire under Section 35 is to be carried out. B, a restricted area has been declared under paragraph 36 sub 1 sub A. C, activities have been prohibited in a restricted area under paragraph 36 sub 1 sub B. D, entry to a restricted area has been prohibited under paragraph 36 sub 1 sub C. Or E, a fire restriction has been declared under subsection 37 sub 1. Thank you, Madam Chair.
Thank you, MLA Johnson. The motion is in order. To the motion. MLA O'Reilly.
Yeah, thanks, Madam Chair. So I guess a couple of points. I think this issue was raised in the last assembly as well. It was raised in writing to us by the NGOs, and we heard this in our travels as well about the need for consistent communications and notice. The way the bill had been drafted, the only requirement for public notice was around restricted areas, fire restrictions, nothing about prescribed burns, and some of the other matters that are now covered in the motion before us. So this is really about broadening the notices to public and clarifying the process for a notice to the public. And I think this is a helpful addition to just make sure that there's more consistent communications on all of these matters. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order to the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. This change helps ensure the public are aware of important forest management activities. Thank you, or I concur. Thank you, Madam Chair.
Thank you, Minister. The minister concurs with the amendment. Clause 38 is amended. Committee to Clause 38 is amended. Does committee agree? Clauses 38 to 40, does committee agree? Clauses 40 to 44, does committee agree? Clause 45, MLA Bonnet Rouge.
I move that Bill 74 be amended by deleting subclauses 45 brackets 2 and brackets 3 and substituting the following. 2. An owner or operator of an industrial activity shall prepare a wildfire prevention and preparedness plan in accordance with the regulations. 2.1. Wildfire prevention and preparedness plan prepared under section 2 must be A, provided to the governments of affected communities for review and comment as required by the regulations, and B, submitted to the forest superintendent. 1, before the start of the wildfire season, or 2, if the industrial activity commences after the start of the wildfire season, before the industrial activity starts. 3, if the forest superintendent is not satisfied with the plan submitted under paragraph 2.1b, the forest superintendent may require the owner or operator to resubmit the plan with any changes that the forest superintendent may direct. Merci.
Thank you, MLA Bonnet Rouge. The motion is in order to the motion. MLA O'Reilly.
Yeah, thanks, Madam Chair. Again, this is an issue that was raised in the last assembly on Bill 44. And I believe it was raised during the public engagement on this bill, and then again in writing to committee by the Northwest Territories Association of Communities and by the NGOs. And what this would do is make sure, and so there's going to be an important new tool created here, which is a wildfire prevention and preparedness plan that would, so people doing stuff in areas that has the potential to create a fire, just want to make sure that there's proper plans in place for dealing with that, and that the onus for that is really on the owner or the operator to prepare those. So that's a good tool in here. The problem with the bill, the way it had been drafted, was that there was no way to coordinate that or work with the community governments. And at the end of the day, if there's a fire within community boundaries or close to a community, it's the community governments that are usually going to get called upon in some way to help fight the fire. So it was felt, we believe that it would be important to make sure that community governments were going to be part of that process. It may be covered in the regulations in the current process, but we felt it would be important to get it into the bill here itself. So that's the purpose of this. I still have some concern with the way this has been drafted, in that this now puts the onus on the owner, the operator, to submit that plan or give a copy of the plan to the community government. I think it should be the forest superintendent doing that, because the forest superintendent is the one that's going to hear concerns or issues. Maybe the owner or the operator might talk to community governments as well, but the onus is, I think, should really be on the forest superintendent to provide that to a community government, as the forest superintendent's the one at the end of the day that's going to have to consider whether the plan is appropriate or not. I would also point out that there is no process in the bill, even with this amendment, to deal with changes to the plans that might arise. They're submitted at the beginning of a season, and there should be a process for amending a plan partway through. And we may touch on that a little bit later as well. And finally, I think there's going to be this was raised to us by the Land and Water Board, that there's going to be a need to coordinate this with land use permitting, water licensing, because they may have some similar requirements with regard to public safety stuff, and WSCC probably has some areas there that they're have some jurisdiction over, so that is going to need to be coordinated and thought through perhaps a little bit more carefully in the regulations. But that's the purpose of this, is to make sure that community governments are part of this process in the legislation itself. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with the amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. This change will help ensure communities are engaged by industry while preparing wildfire prevention and preparedness. So I concur, Madam Chair. Thank you.
Thank you. The minister concurs with the amendment. Getting too old. Clause 45 is amended. Does committee to clause 45 is amended? Does committee agree? Clauses 46 and 47, does committee agree? Clause 48, MLA Bonnet Rouge.
I move that Bill 74 be amended by adding the following after subclause 48 brackets 2. 2.1, a permit or license issued under this section must be consistent with A, any applicable aspects of a forest ecosystem management plan that have been implemented in respect of the area that is covered by the permit or license, and B, any legally binding land use plan that is applicable in respect of the area covered by the permit or license. Merci.
Thank you, MLA Bonnet Rouge. The motion is in order. To the motion. MLA O'Reilly.
Yeah, thanks, Madam Chair. Yeah, again, this is an issue that was raised in the last assembly with Bill 44. It was raised again during the public engagement on this bill. Committee raised this issue, I think, in discussions with the department, and was raised again to us in written submissions from the Northwest Territories Association of Communities, CPAWS Alternatives North, and again by the Decho Land Use Planning Committee. And what this is really about is, as I believe Mr. Redvers correctly characterized, the importance of these forest ecosystem management plans is the foundation for forest management, and that once they are developed, they should be binding on other activities that take place. And so that's what this is about, is making sure that permits and licenses that are issued are consistent with those plans. And then secondly, it would also recognize that other entities have jurisdiction and responsibility for carrying out land use planning that need to be kind of recognized and incorporated into forest management. And those land use plans can be from a variety of different parties. The Mackenzie Valley Resource Management Act provides for regional plans in the Gwich'in and Sawtooth settlement areas. But community governments also have the ability to create plans, land use plans, under the Community Planning and Development Act. And we felt that those needed to be captured in some way. We had some probably more prescriptive language, but this is, I think, what we've come to a landing on, and we're going to maybe have some further discussion about this with the next motion. But I do have one question, if I can, for the department, Madam Chair, and I'd like to know how they are going to interpret land use plan and whether that's going to include community plans developed under the Community Planning and Development Act. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. Mr. Minister?
Thank you, Madam Chair. I'll turn it to the Deputy Minister, oh no, Rohan, sorry. Rohan Brown. Thank you, Madam Chair.
Thank you. Mr. Brown, go ahead.
Madam Chair and Minister Thompson. I'll begin by noting that anyone who wants to carry out a forest resource activity within the boundaries of a community is responsible for obtaining all required authorizations and for complying with all applicable federal laws, territorial laws, community government laws, and potentially Indigenous self-government laws. Though most community governments derive their authority from Northwest Territories legislation, it's important to bear in mind that they are a separate level of government. And community governments are responsible for ensuring compliance with their bylaws in relation to forest resource activities within their boundaries. Just as the Northwest Territories cannot expect the federal government to reflect restrictions, requirements, and prohibitions under our legislation in authorizations that are issued by federal departments, it's not appropriate for community government bylaws to be reflected in authorizations that are to be issued for forest resources under this Act. This, however, does not negate in any way that those community government restrictions, requirements, and prohibitions are in fact legal requirements, and that anyone who wants to carry out a forest resource activity within the boundaries of a community is responsible for complying with them.
Thank you, Mr. Brown. Mr. O'Reilly, would you like to follow up?
Yeah, I would never try to summarize what my legal friend tried to say there, but I do agree that it's probably not appropriate. Well, you could refer to compliance with other orders of government legal requirements in a permit or license, but that's not what this is about. This is ensuring that a permit or license issued is consistent with any legally binding land use plan. All I asked is the department going to interpret that in a way that when they issue a license or a permit, that maybe the forest superintendent, whoever issues these things, is going to look at the community plan or talk to the community government, if it happens to be within their boundary, about whether they should issue a land use permit, or sorry, a forest license or forest permit. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. Mr. Minister?
Thank you, Madam Chair. I would turn it to Deputy Minister Kelly. Thank you.
Thank you. Dr. Kelly?
Thank you, Madam Chair. Of course, we would do that. I think it's really important to recognize, because there are others listening, that many of these amendments, it's not things that the department isn't doing, and they would continue to do those things. I think where the question is what belongs in the legislation, what belongs in the regulations, and what would we do anyways, because that's the way that we do business. We understand and have agreed to many amendments that add in pieces to the legislation that are things that we are going to do anyways. And in this case, we would, of course, talk to the communities about community plans. And I think just for those that are listening too, it's important to recognize that many of these details from a departmental and technical working group perspective, we plan to flesh out more and discuss more with many partners through the regulation development process. But the answer is yes. Thank you, Madam Chair.
Thank you. And yeah, and that goes back to what I had said earlier, that a lot of this is also to get it into the public discussion. So we do really appreciate that this is going to be, the issues that we raised are not being just sloughed off. They're actually just going to be taken up in a different area. So I think committee really does get that. Did you want to follow up? Oh, okay, excellent. The motion is in order to the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
I concur. Thank you.
The minister concurs with the amendment. Clause 48 is amended. Committee to Clause 48 is amended. MLA O'Reilly.
Thanks, Madam Chair. I move that subclause 48 2.1 of Bill 74 be amended in paragraph A by striking out in respect of the and substituting in respect of an and B in paragraph B by striking out that is applicable in respect of the and substituting or zoning bylaw that is applicable in respect of an. Thank you, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order to the motion. Mr. O'Reilly.
Yeah, thanks, Madam Chair. Yeah, this is some fancy words as well to simply try to clarify that that permits and licenses that are issued need to be consistent with not just land use plans, legally binding land use plans, but also zoning bylaws. And zoning bylaws are developed by community governments under, the Northwest Territories, the Territorial Legislation Community Planning and Development Act. And look, I used to sit on city council here, so zoning bylaws are a critical tool in terms of implementing a land use plan at the community level. They provide permitted land uses and specify what's not permitted perhaps in some areas. And they also can regulate the cutting of trees and preservation of habitat according to section 18.1 O and P of the Community Planning and Development Act. And I think there might have been some misunderstanding about the scope of zoning bylaws and what they really authorize. So committee felt that, and this was raised to us by the Northwest Territories Association of Communities in the review of this bill. I believe it was raised in the last assembly as well. And the need to kind of clarify this relationship between forest management and land use planning. And although some of it might play out in the regulations, the committee felt, and certainly the people we heard from, that it would be important to lay some of that groundwork itself in the legislation. So the purpose of this amendment, all these fancy words, is to include zoning bylaws within the scope of the things that need to be, that a permit or license needs to be consistent with. And as I said, that's recognizing the jurisdiction of community governments, and that zoning bylaws are really a natural extension to a community plan and actually could regulate various forest activities. So it's trying to provide that sort of collaborative, upstream, upfront approach to forest management by recognizing zoning bylaws in the bill itself. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order to the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. Process convention pursuant to the IGC Legislative Development Protocol requires that all proposed amendments be reviewed and the GNWT respond provided no later than 1 week before the clause-by-clause review. Though the motion was not provided by committee in time to be reviewed, the addition of bylaws to which creates several practical and legal concerns are of issue. I do not concur with this, but I would like to with your permission, to turn to Rohan Brown. Thank you, Madam Chair.
Thank you. Mr. Brown, go ahead.
Thank you, Madam Chair and Minister Thompson. I don't have much to add to the remarks that I made regarding the previous motion, except to really just emphasize that community governments are a separate level of government, again, with their own authorities and responsibility for ensuring compliance with their bylaws, and that in relation to any bylaws regarding forest resource activities within the boundaries communities, there is no GNWT approval role, and on that basis, it's not appropriate for there to be a requirement for GNWT to have to reflect any zoning bylaws related to forest resource activities in its issuance of permits and licenses.
Thank you, Mr. Brown. The minister does not occur. The amendment will not take effect as a result. The minister did provide concurrence on the previous amendment to this clause. Committee to clause 48 is amended. Does committee agree? Agree. Clause 49, does committee agree? Agree. Clause 50, MLA Whale and Armstrong. think you're muted, MLA Whalen Armstrong.
Yes, thank you. Thank you. I move that subclause 50, bracket 4 of Bill 74 be deleted and the following substituted. 4, a person claiming to exercise an Aboriginal or treaty right to harvest forest resources in an area of the Northwest Territories shall either A, carry on their person documentation that provides evidence of the right being claimed, and on request by an officer produce that documentation for inspection, or B, comply with any applicable alternative requirements respecting documentation that provides evidence of the right being claimed that may be set out in the regulations. Thank you.
Thank you, MLA Whalen Armstrong. The motion is in order. To the motion, Mr. O'Reilly.
Yeah, thanks, Madam Chair. Yeah, this was, I'm going to give you the committee perspective on this, and then I think that members of the technical working group may want to discuss some of their concerns and issues as well. But I guess what committee heard, this was actually another holdover issue from Bill 44 in the last assembly, was that and committee heard directly from Indigenous residents during the public hearings that they wanted their rights recognized and that they felt that they shouldn't actually have to produce or seek permits and licenses to carry out traditional activities. And that there was some concern raised as well about, what identification might be required and how much time they might have to produce it and so on. So when committee reviewed this clause, there really wasn't anything in the bill itself for, basically it said, somebody, I guess the forest management officer comes along, asks somebody for ID. If they claim that they're carrying out a traditional activity, they have to produce it on the spot. There didn't seem to be any time allowed for, production of ID. So that's what committee was kind of concerned about, was trying to provide a time frame for that to happen, because not everybody's going to be carrying their ID when they're out in the bush. So when we raised that issue, there were some additional concerns brought forward by some of the Indigenous governments through the collaborative process we have put in place. They raised some concerns, and I hope that they speak to those. And we worked collaboratively to develop this clause that I think fixes the issue. So for everybody. So I think it's a good piece of work where we work together to fix problems and issues. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. And before I do open up the floor for other comments, I just have to ask MLA Whalen Armstrong to reread the motion. We have just missed a small piece on the following page. So just to ensure that we have the correct motion in order. Jane, could you go ahead and reread that and include part 5 on the next page?
Oh, I apologize about that. Sorry. Yes, I move that subclause 50, bracket 4 of Bill 74 be deleted and the following substituted. 4, a person claiming to exercise an Aboriginal or treaty right to harvest forest resources in an area of the Northwest Territories shall either A, carry on their person documentation that provides evidence of the right being claimed, and on request by an officer produce that documentation for inspection, or B, comply with any applicable alternative requirements respecting documentations that provides evidence of the right being claimed that may be set out in the regulations. 5, documentation referred to in subsection 4 must satisfy any conditions set out in the regulations. Thank you.
Thank you, MLA Whalen Armstrong. And Kevin, I think you're still good for your comments. Thank you. So were there any members of the technical working group that did want to speak to this? Did someone pop up there for a second? I'm not sure.
Yes, it's Paul Bachon here. I just wanted to note that there was a lot of discussion about this particular motion and the subject matter related to identification. We think, and speaking on behalf of the technical working group, we think that the wording that's here today provides a space for special circumstances and processes that can come up in relation to the carrying of personal documentation. First, it could be an individual thing, or it could be a process thing related to the particular type of treaty or agreement that the nation has with public governments. For example, in the Cleachon government case, Cleachon citizens do not carry little card carrying Cleachon ID type identification. And a lot of that is covered because of the Cleachon agreement, in which it is stated that there shall be a Cleachon register of all Cleachon citizens and their names. And that register is required by operation of the Cleachon agreement to be shared with public governments. As such, there could be in the future a process design that's based on that register, and an officer or his or her bosses having access to that register to determine requirements respecting documentation without necessarily having to carry such an ID. We don't know if that will happen in the future, but what happens is this wording will provide the space for that discussion later on to take place, and we appreciate the sensitivity that's been applied to the coming together of this clause. Thank you.
Thank you, and I definitely learned something new about how the Cleachon government operates with their registry. So, Mr. Redvers, would you like to speak to this as well?
Yes, just thank you, Madam Chair, just to support what Paul Bachon has stated, and also to thank the committee for raising this point. It was a good point that was raised. It caused considerable discussion among the technical working group, among the Indigenous governments. We had a lot of wording going back and forth to try and nail this down. And I think it has, in fact, strengthened this particular clause in the bill.
I agree. Thank you. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I'd like to thank Peter and Paul for their comments on here. I support this proposed amendment to the bill. This change will support the flexibility that the technical working group intended during the collaborative development process. So I concur. Thank you, Madam Chair.
The minister concurs with the amendment. Thank you, Minister. Clause 50 is amended. Committee, to Clause 50 as amended, does committee agree? Clauses 50 through 59, does committee agree? Clause 60, MLA Johnson.
Thank you, Madam Chair. I move that Bill 74 be amended by deleting subclauses 60 sub 1 to sub 3 and the heading immediately preceding subclause 60 sub 1 and substituting the following. Appeal from decision and orders of officers. 60.01 in this section and in section 6.1 to 63, approved form means a form approved by the minister. Subject to subsection 2, a person who is adversely affected by a decision or order of an officer made under this act or the regulations, including a decision or order of the force superintendent acting in their capacity as an officer, may appeal that decision or order by filing a notice of appeal in an approved form in accordance with the regulations within 30 days after receiving the decision or order. Sub 2, no appeal lies under subsection sub 1 in respect of a decision or order made under Part 7. 2.1, if a notice of appeal is filed under subsection 1, the force superintendent shall decide the appeal, or B, if the decision or order appealed from is one of the force superintendent or in the prescribed circumstances, an adjudicator must be appointed in accordance with the regulations to decide the appeal. Sub 3, no person shall be appointed under paragraph 2.1b who works in the department. Thank you, Madam Chair.
Thank you, MLA Johnson. The motion is in order to the motion. Mr. O'Reilly?
Yeah, thanks, Madam Chair. Yeah, some concerns were raised around the appeal process, I guess in the last assembly and again in this one in writing to committee as well. And what this does is, I think, clarify the appeal process in a number of ways, and that there's going to be further details, of course, in the regulations, but I'm just going to give a couple of examples of how this clarifies that the process that was set out in the bill. There would be no appeals for investigations and inspections that are carried out under Part 7. We just didn't think that that should be the subject of that kind of dispute resolution. If you don't like that stuff, you go to court to sort it out, and that there's obviously some urgency to do those kinds of things. And it also clarifies that the adjudicator that's appointed shall not be a government employee, or sorry, work for the department, which I think is an important thing. So anyways, this is an attempt to try to clarify the appeal process, and I want to thank the folks that made some written submissions to us for helping us work our way through this. And I think we've arrived at a pretty good solution for now. Thanks, Madam Chair.
Thank you, MLA O'Reilly. The motion is in order to the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. This change will help enhance the bill's appeal process, so I concur. Thank you, Madam Chair.
Thank you. The minister concurs with the amendment. Clause 60 is amended. Committee, to Clause 60 as amended, does committee agree? Clauses 61 through 70, does committee agree? Clauses 71 through 80, does committee agree? Clauses 81 through 90, does committee agree? Clauses 91 through 100, does committee agree? Clauses 101 through 110, does committee agree? Clauses 111 to 120, does committee agree? Clauses 120 to 126, does committee agree? Clause 127, MLA O'Reilly.
Thanks, Madam Chair. I move that Bill 74 be amended by adding the following after paragraph 127C, C.1, prescribing information that must be made publicly available under section 14.1 and respecting time periods within which that information must be published. Thank you, Madam Chair.
Thank you. The motion is in order to the motion. MLA O'Reilly.
Yeah, thanks, Madam Chair. Well, what this motion does is allow for regulations to be made to set out what information should be made public. I'll use the words public registry, but and the time periods in which that information should be published. We had a lot of back and forths on this, whether it should be without delay or whatever, and I guess at the end of the day, we've agreed that that should be the subject of the regulations, and this would enable regulations to be developed to clarify that and set it out more clearly. Thanks, Madam Chair.
Thank you, MLA O'Reilly. The motion is in order to the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with the amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. This change to regulation makes authority changes related to motion 2 and is required for the amendment I previously supported, so I concur. Thank you, Madam Chair.
Thank you. The minister concurs with the amendment. Clause 127 is amended. Committee, to Clause 127 as amended. MLA Johnson.
Thank you, Madam Chair. I move that Bill 74 be amended by adding the following immediately preceding paragraph 127 sub D, C.2, prescribing information that must be included in the annual report under section 15.1. Thank you, Madam Chair.
Thank you, MLA Johnson. The motion is in order to the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this proposed amendment to the bill. the regulations make authority changes related to motion 4 and is required for amendment to that motion that I previously supported. Thank you, Madam Chair. I concur.
Thank you, Minister. The Minister concurs with the amendment. Clause 127 is amended. Committee to Clause 127 as amended. MLA Whalen Armstrong.
Thank you. Thank you, Madam Chair. I move that Bill 74 be amended by adding the following after paragraph 127, bracket Z.01, Z01.1, respecting the provision of wildfire prevention and preparedness plans to government of affected communities under subsection 45, 2.1, including 1, prescribing classes of affected communities whose governments must be provided with a plan, and 2, defining government for the purpose of the subsection. Thank you.
You, MLA Whalen Armstrong. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I concur. I support this proposed amendment to the bill. This regulation makes authority changes related to motion 15 and is required for the amendment I previously supported. Thank you, Madam Chair.
Thank you. The minister concurs with the amendment. Clause 127 is amended. Committee to Clause 127 as amended. MLA O'Reilly.
Thank you, Madam Chair. I move that paragraph 127Z.01 of Bill 74 be deleted and the following substituted: Z.01, respecting requirements for wildlife prevention and preparedness plans under subsection 45.2 and the amendment of such plans. Thank you, Madam Chair.
Thank you. The motion is in order. To the motion. Mr. O'Reilly.
Thanks, Madam Chair. This would amend the last motion that would allow for regulations around the process for which community governments would get the wildfire prevention and preparedness plans. And all this new motion would do is allow for regulation-making authority around amendment of those plans, because the bill itself doesn't deal with it. There's no explicit authority within the regulation making section that we're on for amendment of those plans, and this would just provide the minister with the authority to set out an amendment process. It might be caught under the Z32 kind of catch-all at the bottom of this section, but committee felt that this would be a little more helpful to actually recognize that there should be an amendment process through the regulations. Thanks, Madam Chair.
Thank you, Member O'Reilly. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with the amendment?
Thank you, Madam Chair. This motion is an amendment to regulation making authority for a motion that I have not that I've previously rejected. We already have significant regulation making authority without this amendment, but with your permission, I'd like to go to Paul Beauchamp from the Clecho government to respond to this motion as well. Thank you, Madam Chair.
Thank you, Mr. Minister. Mr. Beauchamp, go ahead.
Yes, thank you. The technical working group doesn't have too much to add to the minister's comments. Indeed, we think that the general provisions will allow for this specific type of consideration when the act is in place and matters are being implemented. Thank you.
Thank you. The minister does not concur. The amendment will not take effect as a result. Committee to Clause 127 is amended. MLA O'Reilly.
Thanks, Madam Chair. So I move that paragraph 127 Z.01.1 of Bill 74 be amended by A, striking out, and at the end of the English version of subparagraph Roman numeral 1 and substituting a comma. B, striking out the semicolon at the end of subparagraph Roman numeral 2 and substituting and C, adding the following after subparagraph 2. 3, Roman numeral 3, respecting time periods within which plans must be provided. Thank you, Madam Chair.
Thank you. The motion is in order. To the motion. MLA O'Reilly.
Yeah, thanks, Madam Chair. This is again this issue of the submission and review of wildlife preparedness and prevention plans for industrial activities to community governments. This would just allow for the regulations to include consideration of time periods within which those plans should be submitted to community governments. Thanks, Madam Chair, or perhaps other aspects of the process. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. No, I do not concur to this motion. This motion is an amendment to regulation making authority for a motion I have previously rejected. Thank you, Madam Chair.
Thank you. The minister does not concur. The amendment will not take effect as a result. Committee to Clause 127 as amended. MLA Bonnet Rouge.
I move that Bill 74 be amended by deleting paragraphs 127 Z.02 and Z.03 and substituting the following Z.02, respecting requirements for hazard assessments under subsection 45 brackets 5. Z.03, respecting the power of officers regarding the clearing and disposal of flammable material under section 46. Masi.
Thank you. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I concur.
Thank you. The minister concurs with the amendment. Clause 127 is amended. Committee to Clause 127 as amended. MLA Whale and Armstrong.
Thank you. I move that paragraph 127, bracket Z21 of Bill 74 be deleted and the following be substituted. Z.21, respecting the form, content, or production of documentation under subsection 50 bracket 4, including Roman numeral 1, the timing of production, and 2, setting out different provisions, A, based on representation by different Indigenous governments or Indigenous organizations, or B, for different areas as specified in the regulations. Thank you.
Thank you, MLA Whale and Armstrong. The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I concur and support this amendment to the bill. This regulation makes authority changes related to motion 19 and is required for the amendment I previously supported. Thank you, Madam Chair.
Thank you. The minister concurs with the amendment. Clause 127 is amended. Committee to Clause 127 as amended. MLA Johnson.
I don't think this is me, so what page are we on?
The overall package? Yeah. Yeah.
Thank you, Madam Chair. I move that Bill 74 be amended by deleting paragraph 127 Z.27 and substituting the following Z.27, respecting appeals authorized by this act, including I, the filing of appeals, 2, the procedures in respect of appeals, 3, the appointment of adjudicators, and 4, prescribing circumstances for the purposes of paragraph 60, 2.1b. Thank you, Madam Chair.
Thank you. The motion is in order. To the motion? Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. I support this amendment to the bill and concur to it. This regulation makes 30 changes related to motion 21 and is required for the amendment I previously supported. Thank you, Madam Chair.
Thank you, Minister. The Minister concurs with the amendment. Clause 127 is amended. Committee, to Clause 127 is amended. Does committee agree? Clause 128, MLA O'Reilly.
Thank you, Madam Chair. I move that Bill 74 be amended by adding the following after Clause 128, 128.1, brackets 1, subject to subsection brackets 2, before making regulations under this act, the minister shall A, ensure that there is an opportunity for public engagement by Roman numeral 1, publishing a copy of the proposed regulation on a website maintained by the Government of the Northwest Territories, and Roman numeral 2, ensuring that a reasonable period of time has been allotted for receiving feedback on the proposed regulations, and B, consider any feedback provided on the proposed regulations under subsection A. Brackets 2, subsection brackets 1 does not apply if the minister is satisfied that the proposed regulations have been prepared in response to an emergency. Thank you, Madam Chair.
Thank you, Mr. O'Reilly. The motion is in order to the motion. Mr. O'Reilly, go ahead.
Thanks, Madam Chair. Yeah, this has been the subject of a lot of discussion back and forth. This issue of the public engagement around regulations was raised in the context of this bill, Bill 44 in the last assembly. It was raised during the public engagement on the bill in this assembly. It's been requested in writing by submissions to us by the Northwest Territories Association of Communities and the NGOs. I think committee recognized all that, and I think it's partly a response to frustration on the part of some of the participants in this process with the delayed public engagement on the bill and the short comment period, and that there was no real direct engagement. And I think the department's rationale was that they did some of that work in the last assembly, but anyways, in my view, this is again a GNWT responsibility. This is not for the Indigenous government's responsibility, but and I think part of a lot of back and forth, as I said, on this. There is a cabinet operational guideline that lays out a process where ministers have discretionary authority over what gets shared or what regulations go to public engagement, and that's basically at the total discretion of the minister. But I think in terms of best practices around public engagement and regulation making, some of those are found in the Petroleum Resources Act, the Oil and Gas Operations Act that we have in place, albeit these were inherited from the federal government. And even in this assembly, the Child Daycare Act incorporated public engagement around development of regulations for childcare, and that those are to be provided in draft form to operators. And I think we may hear from the department that they believe that a government-wide approach is necessary, and I believe that this is extraordinary legislation. It's been developed collaboratively with Indigenous governments pursuant to the legislative protocol. It's, through the process convention, we've reviewed this together. This is not an ordinary piece of legislation, and the regulations that are going to be developed, and we've talked a lot about that today. There's a lot of public interest in these kinds of details, and there should be an effort to ensure that that's done through public engagement, and that's what this clause, this amendment would actually do, is require that to take place. And I think we also heard from the department that there was some concern about whether this public engagement would hinder the minister's ability to bring forward regulations in an emergency situation, and we believe we've tried to accommodate that in the wording that we've proposed here as well. Thanks, Madam Chair.
Thank you, MLA O'Reilly. The motion is in order to the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Madam Chair. No, I do not concur. The GNWT conducts public engagement on the development of new regulations for the Forest Act in accordance with the Cabinet's operation guidelines on publishing of proposed regulations. This motion is unnecessary and has unintended consequences. With your permission, I'd like to turn to Paul Bouchant from the Clecho government, and after he's done speaking, then if you would turn to the Deputy Minister Kelly. Thank you, Madam Chair.
Thank you. Mr. Bachand, go ahead.
Yes, thank you. After some discussion, Cleach government came to the conclusion that this matter can be handled through the current set of engagements and inputs done through both regulation and on a policy perspective and the website. And we didn't have any further comments on this.
Thank you. Dr. Kelly, go ahead.
Madam Chair, as mentioned by the member, the GNWT is committed to transparency and accountability in its public engagement on government decision-making. I would point out that not all acts are the same, and the implications of including this are different depending on what act you're looking at. There are rare but necessary reasons why public engagement may not occur on all regulations. These may include emergency orders or fire bans, and relief from payment obligations implemented through the pandemic or other emergency responses. The GNWT will conduct public engagement on development of new regulations for the Forest Act in accordance with the Cabinet operational guidelines on the publishing of proposed regulations. Given our commitment to public engagement, we feel that there is no need to add this clause to Bill 74. Requirements for public engagement on regulation should be done through a whole of government approach, as mentioned, so that the public knows where and when to engage. And adding requirements into each bill runs the risk that public engagement requirements in legislation can differ over time, leading to different approaches and potential confusion. Further, the GNWT does not want to limit the approach to public engagement by adding in a clause like this in Bill 74. We are committed to developing regulations with input from Indigenous governments and Indigenous organizations, key stakeholders, and through a public engagement process detailed in the operational guidelines. Thank you, Madam Chair.
Thank you, Dr. Kelly. The minister does not concur. The amendment will not take effect as a result. Committee, to clause 128, does committee agree? Clauses 129 through 139, does committee agree? Does the committee agree that Bill 74, Forest Act, is now ready for consideration in Committee of the Whole? Mr. O'Reilly.
Thanks, Madam Chair. I move that Bill 74, Forest Act, be reported to the Assembly as ready for consideration in Committee of the Whole as amended. Thank you.
The motion is in order. To the motion. Question has been called. All those in favor? All those opposed? Motion is carried. Bill 74, Forest Act, will be reported to the Assembly as ready for consideration in Committee of the Whole as amended. I want to thank the minister and the members of the technical working group and all of the staff and the officials who have facilitated the discussions with the Standing Committee and the technical working group to make amendments to this bill. Standing Committee believes these amendments strengthen the bill overall and would like to acknowledge the work of everyone who achieved this. I did just want to say before we pass this over to members of the technical working group that I wanted to thank Member O'Reilly specifically for all of his work on this bill. I know that he was involved with it in the last assembly when it didn't make it through. And in this one, he has definitely been one of the driving forces of a lot of the amendments that have made the bill stronger. And I think it's really been a passion project for you. So I know going forward, Bill 74 will always be Kevin's act in my mind. So I wanted to say that before we close. So if I could, if there are any members of the technical working group that would like to provide any closing comments, please go ahead. Mr. Redverse, please go ahead.
Yes, just thank you, Madam Chair, for your involvement in this process convention. It's, as Member O'Reilly has stated, this is a very new thing, somewhat historic in terms of the engagement that has occurred. And speaking on behalf of the Kapolei First Nation, it certainly grants a recognition to KFN and other Indigenous governments as having a really key and important role in the co-management of lands and resources. And it's certainly in the NWT and certainly consistent with the the spirit and intent of the intergovernmental agreement that the Indigenous governments present today signed off on as a component of supporting the devolution agreement. So a lot of work. I've been in it since day one in terms of developing the act, the original one for the previous legislative assembly and this one. And I don't know if I'm going to be getting too old to be able to last through the development of the regulations, but certainly we've got a good solid base to build on.
Thank you. I feel like
I'm
Kevin.
not going to die or pass away. I just don't know if I have the energy for it.
Maybe you'll retire, and I have a feeling that you might see Member O'Reilly as part of all of the regulation-making time as well. So, Mr. Minister, would you like to provide some closing remarks?
Thank you, Madam Chair. First and foremost, I'd like to thank committee for all their hard work. I concur with you, Madam Chair, about Mr. O'Reilly, Emily O'Reilly. He was very passionate about this in the 18th Assembly, and you can still see his passion is that, you know, still here and committed to this process here. So I thank him for that. But I also really need to thank the technical working group. They've done an amazing job. It's been a long process, and they've been very committed. I think it was over 15 meetings they had as we worked on these bills and these amendments. So I have to say thank you to them. And I think the work that has been done collaboratively between committee, the technical group, and the department will enhance this bill and it will make it better. And so for that, I am very thankful for. And again, at the end of the day, I thank committee for the work that they did in the technical work, and as well as the department. The department is very committed on to making this bill improved. And again, I think that these amendments that were passed here today are make that bill more enhanced. So thank you very much, Madam Chair and committee. And your staff. Sorry, forgot to say your staff. Your staff has done an amazing job as well. Thank you.
Yes, thank you. I'd be remiss if I didn't mention our advisors clerk and our law clerks. It was a lot of back and forth between everybody, and it really was quite exciting to be part of this new convention, and reassurance to the committee that, you know, there's always going to be that Indigenous feedback into these future regulations as well, and that was very reassuring to all of us. So, and I just wanted to say before we close the public portion of the meeting that, you know, the committee has it's really impacted us that as we did this work on the Forest Act, you know, the territory is burning. And so we just wanted to say that, you know, our hearts are going out to everybody that's displaced, to the department. We know it's a difficult time and everybody is overworked and worried not only about what they're doing in their work, but also about their friends and family around the territory. So I think it's really impacted us as a committee that this was going on at the same time as we were doing this work. And it really shows us that what we do isn't just, you know, process and words and legalese. It's actually going to have an impact on people's lives. So thank you so much for that. So this concludes the public portion of our meeting. Is there a motion to go in camera? Mr. Johnson, thank you. Has moved the committee into camera. The motion is in order. All those in favor? All those opposed? The motion is carried. We will now go in camera. Members, we will take a 5-minute break and then we will proceed with our in-camera matters. Thank you. Thank you, everybody.